Welcome to today's program titled Time Well Spent, Session 2, Shifting Standards of Conditional Certification. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our moderator for today's program, Kelly Kelker. Kelly, please go ahead.
Good afternoon or good morning to you, wherever you may be. I am coming to you from California with some video problems, but we'll be monitoring this session, and if all goes well, the future sessions of this Time Well Spent series. I came to this moderator job by virtue of my responsibility for providing the semi-annual updates to our ALM wage and hour class and collective action treatise that some of you may receive. But my job today is mostly to keep the train running on time and to turn it over to our speakers who are going to talk today about perhaps one of the most important topics covered in our treatise, and that is conditional certification standards. Some of us remember when Lusardi was a young decision and whether that made sense as a way to handle FLSA collective actions. And the courts very recently have begun to re-examine that standard. And so I'd like to turn it over first to Lennon Haas, who is part of our Atlanta wage and hour practice group, who has experience in all kinds of complex collective and hybrid actions in many jurisdictions. And he has given advice on the full life cycle of these kinds of cases, including notice and merits and decertification. So Lennon, would you like to kick it off with a first look at what the Fifth Circuit has been doing with the conditional certification standard?
Absolutely. Thanks so much, Kelly. Let's go to the next slide. So real quick, before we get to this Wales decision out of the Fifth Circuit, I think probably most of us are familiar with Lusardi. It's a 30-something-year-old decision at this point, but for so long, the way these cases have gone is that fairly early on in an FLSA case, the plaintiffs will move for, quote, conditional certification, which is, of course, not something that you can find in the FLSA itself. It's a judge-created device for managing the notice process, and the burden on a plaintiff at that conditional certification stage is very light. And so for many years, plaintiffs have achieved certification probably about 85% of the time. And the case proceeds on an aggregate basis thereafter throughout discovery. And so defendants have, for so long, suffered the burdens of litigating on a class basis before a decision has actually been made on whether the statutory standard has been satisfied. Step two is decertification, usually occurs after discovery. It's a higher bar, but by that point, the much of the damage has been done. A lot of cost has been imposed on an employer, a defendant, and it is as stringent as decertification is. It's still not the world's highest bar sometimes. So let's go to the next slide. For decades, Lusardi kind of ruled, and courts across the country and circuits applied it pretty religiously. a deviation here and there in specific circumstances, but by and large, that's the rule that's been applied until 2021, when the Fifth Circuit um, decided to kind of break from the pack and decided the Swales decision and explicitly rejected Lusardi, and really it did so on a very textual basis. So it looked at the text of the FLSA and it said, look, this certification process that Lusardi laid out, it's nowhere in the statute. And just because it's happened for 30 some odd years, it doesn't mean it's right. And the court said, what the statute requires for a case to proceed on a collective basis is that the plaintiffs be similarly situated. If they're not, the case can't proceed that way. And I think the court took a pretty practical view of what happens after a collective is conditionally certified and said, look, you can call it conditional all you want, but practically speaking, it is certification, and courts are allowing these cases to proceed on an aggregate basis without actually determining whether the statutory requirement of similar situation has been satisfied. And so the Fifth Circuit set out what's a pretty common sense three-step framework for how to proceed. A court should first ask, what factual and legal questions are going to be material to the similarly situated analysis in that particular case. And that's going to vary from case to case. So, for example, an independent contractor misclassification case, the relevant facts to that inquiry are going to differ from the facts that matter in, say, a professional exemption case. They're going to differ from an off-the-clock case. So first things first, you got to determine what facts actually matter to that particular inquiry. And second, there should be some discovery on those facts before any certification decision is made. And I'll just pause for a second to say this verbiage of certification, that's nowhere in the statute either. It's all about notice, and there's a tendency to talk about certification, but that's not really something that's in the FLSA. And so it might be more accurate to say that courts should authorize discovery on facts relevant to whether they should allow notice to go out. So step three, after that discovery has been had, that's when a motion for certification or motion to a permit notice should be filed under Swales. And courts at that stage should analyze all the evidence. Under Lusardi, a lot of courts will not look at evidence that a defendant might submit in opposition to a motion for conditional certification. But under Swales, the court's supposed to look at everything and decide whether or not the participants in the case are similarly situated. And if they're not, then the case cannot proceed on a collective basis, and the named plaintiff or plaintiffs can proceed individually. With that said, let me pitch it to Kyle to talk about another new decision in this area.
And before Kyle starts, this is Kelly again. I just want to introduce Kyle. She's a partner in our Chicago office and a member of the Wage and Hour Litigation Group, who devotes a lot of her time to defending employers all over the country in class, collective, and complex pay, overtime, hours-related lawsuits, and has defended lawsuits involving misclassification, off the clock, and regular rate claims, all sorts of things. So, Kyle, you want to take us to the Sixth Circuit?
Yes, thank you, Kelly. Thank you, Lennon. We had great news out of the Fifth Circuit back in 2021, and no longer does Swales stand alone in such a stark break from the Lusardi standard we've all lived with for so long. In May of this year, the Sixth Circuit took up the question of, what sort of showing is required in order for notice to issue to potential opt-in plaintiffs in the Clark versus A&L Home Care case. The case was before the Sixth Circuit on a fairly rare interlocutory appeal. We don't tend to see a lot of appeals of conditional, or what I'll air quote, conditional certification decisions, because they are not final rulings. But the court somewhat reluctantly applied Lusardi and granted, at least in part, the plaintiff's motion with respect to two putative collectives, and but at the same time, acknowledged Swales and the arguments that the defendants were making that Swales, should rule the day and Lusardi should be tossed out. And the judge wasn't quite willing to adopt Swales, given the long history of Lusardi within the Sixth Circuit, but did, call into question the foundation upon which Lusardi was built, sort of similar to the Swales court, looking to the text of the statute, and so took it upon itself to certify the order for interlocutory review, and the Sixth Circuit happily obliged for our purposes. So then on appeal, not surprisingly, the plaintiff argued for the continued application of Lusardi and the very lenient standard, while the defendant urged the court to adopt a Swales approach. Well, the Sixth Circuit didn't do either. The court instead, rejected the lenient standard in Lusardi, and similar to what Lennon was talking about with Swales, there really took sort of issue with the characterization of notice as certification, because again, it's not in the statute anywhere. It's a court-created construct, and when under 216B, people are invited to join the case, and that's really all that happens. They're not. It doesn't change the character of the case into a representative action. But the court didn't fall in line with Swales, and the Fifth Circuit, it adopted a different standard, but a welcome one nonetheless. The court sort of hung on to a two-step approach, but sort of jettisoned the lenient standard at the initial stages and essentially held that in order to get approval to send out notice, the plaintiff has to show a strong likelihood that the folks they want to send notice to are similarly situated to them. And sort of landing on that strong likelihood language, the Sixth Circuit was borrowing from the law that we see in the context of preliminary injunctions. And the court reasoned that a motion to send notice and a preliminary injunction are somewhat similar, and they're both provisional rulings. In the case of a preliminary injunction, of course, the movement needs to make a showing that it has, there's some degree of probability of success on the merits of their claim, and somewhat akin to that, the Sixth Circuit said, a plaintiff seeking to send notice in an FLSA case must show there's a strong likelihood or a high probability that the putative opt-ins are in fact similarly situated to them. Now, what's a strong likelihood? Something more than required to create a genuine issue of fact in the summary judgment context, less than the preponderance of the evidence standard, which is sort of how the Sixth Circuit looked at the Swales standard. They said, Swales is requiring, preponderance of the evidence, and basically, making a final determination on the similarly situated question before you even have those folks before the court. And so wasn't quite comfortable going that far, and felt that its strong likelihood standard struck a balance, and that it would have the effect of limiting notice to the extent practicable to those employees who are likely to be similarly situated, but without making sort of a final determination on that with respect to people who aren't yet before the court. The court did, though, acknowledge that in order to apply that strong likelihood standard, some discovery was likely going to be needed, which really opens up the door for employers to finally, after so many years, get the opportunity to develop and present evidence that will actually be considered by a court. we often have developed that evidence and presented it only to have it completely disregarded by courts time and again, thanks to Lusardi. So a very welcome change from what, seemed to many of us rubber stamps on certification motions supported by not much more than plaintiff's allegations or a couple friendly declarations. The court in Clark did raise some concerns, or at least, some mention of the potential impact that pre-notice discovery could have on the timing of when notice might go out, given that in FLSA cases, the statute of limitations continues to run until somebody affirmatively files a consent and to join the case. But stopped short of endorsing or requiring equitable tolling, but did say that district courts, trial courts should promptly be permitting this discovery and should expeditiously rule on motions to send notice when they hit their desks. I will add that in the concurrence to this decision, the judge there went a bit further on that point and really advocated for equitable tolling because of the impact that discovery will have on potential claims of the putative opt-ins. And so, although the Sixth Circuit didn't go quite as far as Swales, it's nonetheless a very encouraging and helpful decision for employers. And it gives us really, like I think, Lennon mentioned, both under Swales and Clark, the opportunity to, bring out and highlight how individualized the defenses that employers will offer are. Those arguments have so often been just rejected prematurely or been rejected by courts saying it's premature, it gets into the merits, and we can't look at that. So I know at least I personally found it very satisfying to see the Sixth Circuit acknowledge that, the very point of the similarly situated analysis is to determine whether the merits of other employees' claims would be similar to the merits of the original plaintiffs, such that collective litigation would allow for efficient resolution of common legal and factual issues. And so now, we've got a fighting chance when opposing a notice motion to, present evidence of variations in the situation of the employees, whether it's their job duties or hours worked and individualized defenses on exemptions and the like. And a court will, at least sitting in the Fifth and the Sixth Circuit, take those into account. So that's a breath of fresh air for those of us who have been in the trenches for the last a minute. I won't speak for the rest of you. It's been a while. All right. So
thank you, Kyle. Thank you. As you alluded to, it's one thing for the courts of appeals to announce these standards, and another thing for the district courts to actually apply them to the facts of the cases that are in front of them. So, Lennon, can you comment on what the district courts have been doing, both inside the Fifth and Sixth Circuits and outside, if there's been any action in other circuits along these lines?
Yep, absolutely. Let's go to the next slide.
Probably one more.
Well, I'll hit this one real quick.
Okay.
I just want to note that, Clark and Swales are similar in some respects, but, Clark is definitely not as high a bar. You don't have to prove similar situation in Clark if you're a plaintiff for notice to issue. And as we'll see in a second, I think that some courts are resistant even to the Clark standard. That said, I think that there's some thinking that needs to be done in any given case over, which standard you might want to be arguing for. We'll touch on that in a little bit later in the presentation, but let's go to the next slide. So district courts within the Sixth and the Fifth Circuit obviously are bound by these decisions. The Fifth Circuit district courts have generally been very quick to adhere to swales tightly. The Sixth Circuit's been a different situation. A lot of district courts there are interpreting Clark very narrowly and are finding ways to wiggle around that strong likelihood standard. Sometimes they are saying that uh, a certain amount of evidence that on its face kind of looks light is in fact enough to show a strong likelihood. And we don't have a lot of guidance yet, obviously, around what that means. All the Sixth Circuit said was, yeah, it's like a preliminary injunction, but that's not a whole lot, and they didn't actually cite anything when they were laying out the standard. They just kind of talked about it, and so I think we're going to have to see how that develops to see, what volume of evidence is necessary in any given case. So that's one thing that's going on. Outside of those two circuits, from personal experience, I can tell you Swales is an uphill climb. There have been at least a handful of district courts. One in the Northern District of Alabama, the Broom decision, and then another in, oh goodness gracious, the district court's escaping me. Eastern District of Virginia, that has adopted swales. But the cases that have adopted swales, they are all independent contractor misclassification cases, which swales was. And so we're not seeing yet cases, let's say, an exemption case or an off the clock case.
To Kyle to sort of pick up on the thread that Lennon had started, which is maybe the thing folks are most interested in, which is some practical strategies that employers should want to consider when they're presented with a complaint alleging collective wage and hour violations. Kyle?
Yeah, sure. So, I think Lennon mentioned this, that, swales may be an uphill battle in some places, and, you really are going to need to sort of think about and look at, where your case is, which circuit you're in, what the, historical decisions have looked like. I know, in the Sixth Circuit previously, the Southern District of Ohio, was very, very quick to allow notice to go out in pretty much any case. They sort of viewed it as automatic. So not surprising that there's some resistance to Clark, not swales there. But, outside of the Fifth and the Sixth, sort of taking into account who your judge is, what your situation is, whether you're going to sort of try to press forth a swales approach, or perhaps maybe Clark is the standard you want to advocate for. It could be that swales might be a bridge too far for some courts, sort of streamlining it down to this one decision where you're really deciding the notice question fairly, I say early, but, as a practical matter, it may not, strictly speaking, be early, but before notice in any case. You're really making sort of a final decision on that. And, Clark maintains, some familiarity in terms of the two-step approach, so that may be an easier sell for a court to accept, and they may be more open to that. I think, in either, whether you've made the decision that Clark or swales is the standard that you're going to try to pitch to the court, either of those, I think, provide an opening to advocate for expedited discovery and early consideration by the court on these notice motions of all the available evidence, and not putting your head in the sand and ignoring the evidence just because there's a lenient standard under Lusardi. So I think there's a lot of opportunity there to start pressing forward with discovery. Another factor that I sort of mentioned before is the statute of limitations issue and the possibility of equitable tolling. And I think, to the extent that a court is going to permit, or you're in one of these circuits where the court should be permitting the discovery on the similarly situated question, I think, employers need to be prepared to move quickly into discovery and marshaling their evidence and taking depositions because, courts may be concerned about claims wasting away and falling off as time marches on, and they may be more open to certifying, I use those quotes, sending out notice, giving equitable tolling while they consider the certification and notice. And tolling makes a difference. It can really impact the size and amount at stake in a case. And so, whether, if you've got claims that are equitably tolled while you're working through the discovery issue, you're going to want to keep that in mind to the extent it's going to continue to increase the size of your claims. I don't know if we've got Lennon back
Thank you, Kyle. I think we have Lennon back with us by phone at least.
Oh, Lennon, he can jump in and pick up all the crumbs I missed.
Yes, Lennon, any further thoughts on litigation strategy? And I see that Kyle has noted that it's unlikely to reach the Supreme Court, and I'd like to hear your thoughts on that as well.
Yeah, absolutely. I mean, I think that the decision, speaking from personal experience, I think we've found that it's a very case and judge and district dependent decision whether or not you want to argue for one or the other of these cases. In some places, it may make sense to swing for the fences. In some others, it may, you may want to keep your powder a little drier and argue for Clark. In terms of the Supreme Court, I agree with Kyle. I don't think that this is, at least anytime soon, something that's going to reach the court. So neither Swales nor Clark saw a cert petition. And I think realistically, there's going to need to be a good bit more percolating. And I think you're going to have to see probably a couple of more circuits come out, maybe if you end up with 3 or 4 or 5 different standards around the country and there's, some chaos and some practical impact for either plaintiffs or defendants in these cases, then maybe there's a greater likelihood of the court taking it. But it's difficult for me to see right now why the court would grant cert in one of these cases. So we'll see, though. It may, fast forward 5 years and we could be in a completely different place.
Thanks, Lennon. I guess that means we all have to be very well tuned in to what's happening inside each individual circuit and even within each district that we're confronting certification, and again, also using that in quotes, cases in. Thank you, everyone, for joining us for this first installment of our Time Well Spent series. And I want to announce the CLE code for those of you that may be seeking CLE credit. It is SS, as in Seyfarth Shaw, 7412, SS 7412. Thank you so much for joining us. And again, please look for invitations for future installments of this Time Well Spent series in celebration of the 10-year anniversary of the publication of our ALM collective and class litigation treatise on wage and hour issues.